Good morning. Welcome Commissioners Court, regular session with amended agenda, Monday, February 10th. We have a full quorum present. Jerry, you can certify the meeting was properly posted. Would please rise for prayer and pledges. James Ray.
Father, we come this morning asking for your presence in this courtroom. That you may guide these gentlemen and be in their heart, that they may hear your voice, that they may lead us and the people of this county in the direction that you would have us go. Father, we pray for all those that are hurting today. Many are here that are healing from something. We just pray that you send your spirit upon them. Father, in Isaiah chapter 26 and verse 3 in the King James Version says, thou wilt keep him in perfect peace, whose mind is stayed on thee, because he trusteth in thee. Father, we're trusting in you this morning. May your presence be made known. In Jesus' name we pray. Amen.
And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor and justice to flag. I pledge allegiance to thee, Texas, one state, under God, one indivisible.
I didn't get any citizen input. Anybody got that one? Consent agenda contains 20 items.
I don't have anything to pull.
Make the motion to approve the consent agenda as presented.
Moved and seconded. All in favor, raise your right hand. Motion carries. Statutory agenda number 21, discuss civil process of constables. Yes, sir.
I won't take up much of your time. Y'all remember 3 years ago, I came up here to the court budget, asking for help, asking for deputy, asking for help with the backlog of work, civil process. I didn't have any luck, so I came back the next year. I asked, same outcome. So last year, I thought, why waste my time? Why waste your time? So I didn't come ask, and I'm not asking today. But, I had Phyllis at Constable Central do a count last week. It's 425 civil papers and boxes down there. I know we're supposed to, as elected officials, we're supposed to work 24/7. And that's what we all tell everybody. I'm getting old. I can't work 24/7 anymore. And, the worst part about that deal, and I wasn't raised that way, but Walker County is collecting money for a service. Every day down there, she's taking checks in. Every month she bills the attorney general's office. And it ain't getting done. People are calling daily, won't know why their paper isn't served. I spoke to a couple of y'all about it, but I don't want it to be, I want it to be brought out in the open, you know what's going on. I'm not trying to keep anything a secret. But I'm behind. $100 a paper. 425, that ain't hardly good with that. So I just kind of want to bring that to y'all's attention. I'm not here asking for anything. I didn't have any luck in budget time. I know I ain't gonna ask for nothing today, but that's where we're at. I just want to let y'all know. I'm doing what I can do. If I take a day off, whether it be take my sick wife to the doctor, I don't have anybody to take up the slack for me. It just sits there in a box, or it sits there till I get back. That's kind of all. I just want to bring that to y'all's attention. See if you had any advice or have all the wisdom y'all have on this. Maybe y'all got a better idea.
I definitely think it's a budget conversation, but prior to that, I would invite you to visit with the precinct 2 constable on the program that he put in place. That we have, he's coming back in the next month or two with a presentation. I don't know where he's at with it, but if it's working and it's making a difference in his precinct, I would invite you to be a part of coming back and maybe discussing that for your precinct.
Well, I think I don't necessarily agree with what he did, but that's his bit. He did what he thought would get him some help at the time, but I think he settled for a whole lot less than what he should have. I don't quite agree with having to go out and try to hustle, hire. I do have a couple of reserves, and some of them been in law enforcement for a long time and for whatever reason got out, but they have real jobs that take up their time. I mean, they can help me occasionally, but on a regular basis, they wouldn't be able to. So then I've got to go out and try to recruit reserve deputies. And I'm not saying there's a lot of good reserves out there, but a lot of them have got into law enforcement the wrong thing. Some of them got into law enforcement just because they wanted to have a badge and a gun, but they never even worked in law enforcement. They don't have any. You got a bunch of rookie kind of guys. I don't usually have those as reserves. All my reserves are older and been around a long time, and I try to stay away. We get calls, I ain't gonna say weekly, monthly, quite a few calls to Constable Central in my office. There's guys they want to be reserved, want somebody to carry their commission, but I try to stay clear of them because it's, people I don't know, and I just hadn't done that. But then, I just don't think that's the route, and before he even went to that, like I said, I don't get in a long deal, but, I had offered to the court, if we'd have hired one full-time person, maybe I could have used that person 20 hours a week, him using 20 hours a week. That didn't seem to work, and then went to deal with the reserves, but I'll talk to him. I'm not saying I won't, but I'm kind of against that. I'm not wanting to go that route. So,
Okay. All right.
and then, so, I will, I'll see. I hadn't talked to him. I know he's got it. I don't know how it's going. Go from there, but like I say, I feel bad. I don't know what to tell these people. I'm not gonna tell Phyllis to stop taking those papers. She's gonna intake them and in the system. She's gonna send a check to wherever it goes in the county. It gets cashed each month. She bills. Now the AG is only 66%, so $66 a paper. It's not 100 on those, but they get billed every day. That's all I got.
All right.
Thank you, John.
Thank you.
Bill number 22, emergency management, discuss and take action on approving resolution 2025-31 hazard mitigation plan for Walker County and the city of New Waverly and the city of Riverside. Davis?
Finally have got the grant approved by FEMA for our hazard mitigation plan. It has to be adopted by the county, and the two cities, the city of Riverside is meeting this morning and gonna adopt the hazard mitigation plan. We're requesting that the court approve the Walker County hazard mitigation plan.
That's my motion to approve the resolution 2025-31.
Second.
Moving seconded, all in favor, raise your right hand. Motion carries. 23, discuss and take action on award of bid C2360-25-011 generators under hazard mitigation grant.
These are grants that we put in back during the COVID period. This one was awarded under the winter storm period. We had 4 vendors bid on the project, and I'm requesting that we award the contract to McCafferty Electric. They were the low bid on the 3 projects.
They got a question?
No. I'm good with it.
That'll be my motion to award the bid to McCarthy Electric.
Second.
Moving seconded, all in favor, raise your right hand. Motion carries. 24, receive an update on FEMA.
Okay, we, just to let you know, we have several projects that are in. We've received payment on one project. It was the culvert project at Paul Dixon, the culvert at Ravenwood, covered at Thompson Street, the head wall and approaches at the rail.
And, they have all been, approved and, obligated. We're waiting on, funding to come in on those. We met with the hazards, the mitigation team last, Wednesday. Went over the, Roy Webb Sterling Chapel Bridge, looked at it, and went to the DA's office and looked at it. They're supposed to get back with us on that. We still have some stuff that we're waiting on. Our Cat B emergency protective measures, we're getting the paperwork in that we've had to redo a couple of times. The debris, we're waiting on the PDMG over debris to the project manager to let us know. We have give them everything that they've requested in a very timely manner, and they're kind of dragging their feet on that. And that particular project will be paid at 100%, 75% from FEMA and 25% from TCEQ in the state. On the Cat C projects, we have 4 very large projects. Precinct 1 is a little better than 50% finished with their project. Talked with Steve Lucher the other day. He said they have 285 project sites, and they have 185 of them done. So they're a little over 50%. Precinct 2 has lots of sites, and they're a little over 50% through with their projects. Precinct 3, I think likes 3 votes. In Green Ridge Shores, having all their projects complete. And Precinct 4 is totally complete with the project. We're just waiting on some last minute paperwork so we can submit that as a project.
Appreciate the
Not
help on that,
answering
Bush.
any questions y'all got.
Nope, thank you for doing what you do on your side. I know we work you to death.
Yeah, we appreciate what y'all do.
Work.
It'll be, funding come. Citizens of Walker County won't have to.
Absolutely.
Get-
Yeah, there was an extreme amount of damage from those rains in last spring, and precinct 2 took a lot of damage, more than the hurricanes,
Yeah, this was worse than hurricane.
way worse than hurricanes.
It really was. It really knocked us back. So, we just appreciate getting the paperwork in, because after the paperwork gets to us, it takes quite a bit of time to put that stuff into FEMA forms and then get it submitted to, FEMA. And they're gonna ask you bunches of questions, and we're gonna have to justify everything. So, but we appreciate y'all's help on that.
Thank you, Butch.
Appreciate it.
Number 25, discuss and take action on registration for TAC 2025 cybersecurity training. Amy? Morning.
This is our annual cybersecurity compliance training again. Texas 2054.5191 requires all county employees to take the training each year. So it's a multi-step process. The first step is that I ask Commissioner's Court for approval to enroll. Then I'll do all the templates with them. We'll send out the links to all the employees. They'll take them. It is $5 an employee. I figured it on 350. It would be roughly.
I love how they mandate us to take it and then they
And we
charge
have
us.
to pay for it too. Yeah, the first couple years it was free. Now they charge us.
It's not free now.
It'll be $10 next year. Yeah.
It's roughly $750, but that was on 350. We don't have that many that, because not all employees have to or have access. So, I mean, that would be the most, but in the next coming months, I'll be sending out the links for y'all to get that done.
Thank you.
Thank you, Amy.
Second.
Moving and seconded, all in favor, raise your hand. Motion carries. 26, discuss and take action on purchase of a 2024 Brazos 40-foot Boss Belly dump trailer from Brazos Trailer Manufacturing LLC in the amount of $35,050 through buy board.
Morning.
Morning.
Morning, Miss Cheryl.
Cheryl has been working on this for me. This place is up the other side of Canton, cheapest place we can find. They were on buy board. This is the price they give me. The only difference is this truck is supposed to be black. This trailer is supposed to be black and white, but the price is fine. So, any input?
No, sir.
That's my motion.
Second.
Moving second, all in favor, raise your hand. Motion carries. 27, discuss and take action to issue a solicitation for lime, fly ash, and fly ash blend for road and bridge.
We've had a request to purchase lime, fly ash, and fly ash blend. Austin White Lime used to supply, they sold out to a different vendor. We say La Hoist, but it's pronounced Lavoist. And so we have contacted several vendors to supply it. They say they will, but it's kind of like that crap for rock that we've been on, getting them to answer, but we're willing to try.
Yeah. I'd ask her to look into this because we're getting to our season.
Yeah.
And we, a lot of the blend don't have any on contracts. Why I ask her to relook at all of it. And we're gonna look at it delivered per mile and
That's-
everything.
that's the
That's the
next
next one.
That's the next one. They own it.
Well, and we didn't, most of us didn't do, well, y'all didn't do anything last year either.
No.
We didn't either because of what went on in the spring with the floods and stuff, so. We didn't need it last year, but we're good.
So my motion is gonna be to approve item 27 as presented.
That's,
Moving second, all in favor, raise your hand. Motion carries. 28, discuss and take action to issue a solicitation for hauling lime, fly ash, and fly ash blend.
So you have to have a pneumatic truck to haul the line and stuff. It's not just a belly dump or whatever. It has to be a pneumatic trailer. And we are requesting, in case the vendor that can sell lime, if they can't deliver it, if we could do a solicitation for possibly hauling, having a special person haul it to us. That way we would.
yeah, we'd have to proposition like, RDS, I think they used to haul for, Austin White Lime. There were several companies out of San Antonio, Austin area that do it.
My fear was is that they probably wasn't getting it. It was the hauling. So
Yeah.
that's why I wanted to look at,
Both of them, yeah.
yeah, both of them. That way we have more.
Options.
Options. My motion is gonna be approved as presented.
Second.
Moving second, all in favor, raise your hand. Motion carries. 29, discuss and take action on Aquilas Group Masters intergovernmental purchase agreement for cooperative purchase.
This is like the TASB, it's a cooperative purchasing. It opens up more opportunities for quicker purchases, easier. I did a little research on Aquilas, and their roofing and paving and security services that they're offering. Not only do they offer these, they offer a lot of others, but they're a little bit less expensive than what we have out there now. So I thought I'd bring it to you guys and see if y'all would be open. Again, this is just like the TASB interlocal. We have to have an agreement with this group to be able to procure through their cooperatives.
Sounds good to me, Miss Cheryl. I'll make that motion to approve.
So what does it cost, Cheryl?
Nothing,
So there's no membership fee or anything?
no
like that?
membership fee or anything. It's basically, I just have to have y'all's approval to use them.
And you said they're
It's just
cheaper.
another tool.
And cheaper.
Mhm.
Is there let's say we sign up with these folks,
Mhm.
is there a view only access that we could have? As, if we're looking for something price wise, my board is somebody used to have one. I don't know if it still does. or not.
Anybody can go out there and look on their website and see what is available. But if you really don't want to do that, call my office.
we'll be
Sometimes I
more
like-
than happy to either
Yeah.
send you a link. If we find it, we can send you the link to where you can just click on it, look at it,
Okay.
keeps you from searching everything. But yes, sir, it is. It's
Okay.
it's available to anybody.
All right, thanks.
I'll give you a second.
Moved and seconded, all in favor, raise your hand. Motion carries. Laura, you want to tell Commissioners Court what happened to you last week?
Sure, I passed my, contract management certification.
Oh,
Good.
Very good.
Proud of you. Hi.
You-
That's major.
Congratulations.
All right, number 30, discuss and take action on public information requests when directed to Commissioners Court.
Yeah, I had that put on. I kind of was a little concerned.
Come on.
Help me out. Let me just shut up. Go ahead.
Well, okay, I'll make a couple of comments. First of all, every elected official, and you all know that, you had your mandatory training. Every elected official is responsible for his or her own public information requests. That's simple, that's clear. Where it gets complicated is when someone directs a public information request to the Commissioners Court. And in that situation, it helps to have a designated office as the clearinghouse for that. The appointed official, Andy's office, for example, or Office of Emergency Management, those offices, IT, maintenance, those offices are not elected official. And so an unelected official is responsible for their public information requests. That should be the county judge. If the OEM would definitely be the county judge because he is the person in charge of it. IT, you do that as a body. And so it's kind of like, okay, so the Commissioners Court is going to be responsible for it. Commissioners Court's not an elected official. You're all elected officials, but the court's not. So it's probably best practice if the county judge's office is
Collection.
the collection and responding office. Now, what that means is the county judge's office, they would search what they have. They would then reach out to the appointed officials' offices for what they have, gather that up and send that over. As an elected official, if the request comes to the court and you are also served with that same request, you can respond yourself directly. That's certainly within your purview. If you choose to send it to the county judge and have his office send that out, that's also acceptable. And so I know we've had some requests recently. There's some uncertainty about who's responsible for this and that. And so, I mean, that's kind of the basic position there. So our recommendation is use the county judge's office as the clearinghouse for a Commissioners Court directed request. And obviously for any of the appointed offices.
I think that the open records request or request for open records is, well, has legal implications if you don't respond. It has legal implications if you send incorrect documents. So if you send, then we don't have to, we don't have to create a document if we don't have it, but some people might. So to me, every request for a public record, no matter who it goes to, Commissioner me or appointed or whoever, should be forwarded to the county judge. We should document the date we got it. We apply some sort of a record number to it. And then at that time say, hey, commissioners, I was asked for this. Send me what you have. And then the response comes from the county judge's office. Because let's say it comes to my office. I just choose not to respond to it. Then it was kind of sort of on me, but it's on Walker County also. I mean, legally, it's me. In the newspapers, the county didn't respond. So it's one of those things that it's got visuals to it that are, whether they're legal or not, they're still visuals and people see. So having an organized process of like, if you receive an open record in Andy's office, county judge needs to know about that immediately. Hey, I just got this. Fine, here's the date, here it is, March 10th or March 4th or whatever like that. That's a response date. Either send me what you're sending or send me that you responded to it. I think having a policy and a process simplifies it, because if it comes to the commissioner's court, if he sends a document that's his record, and I send a document that's my record, and they don't match, that's a problem. So I think consistency on every response, no matter who it comes from, with a record of when you got it, when it was responded to, is simple and easily, not only just to defend, but to explain, and probably more acceptable.
I'll say that any requests into the commissioner's court, I would recommend that the judge's office be the responding office, that anything you have in your files, anything anybody has in the county that some of these appointed or department heads, things of that nature, that be forwarded to the judge's office to do the response. Anything sent to an appointed official's office, that should also be sent to the county judge. Now, the county judge's office is not going to have those records, but
Exactly.
they would keep a log. This request came in. This office provided this information. This is when we responded. I agree with that.
Will you define appointed official?
Yes.
Are you
These
talking
are-
county auditor,
these are-
purchasing agent, CSD, and juvenile?
Yes. These are offices that are headed by someone like Patricia, who was not elected. The two types of office leadership we have in the county are elected officials. You have 22 of those, and appointed officials. These are the people, there are 12 of those, so 10. And so those 10 offices, purchasing, auditor, EMS, maintenance, IT, planning and development, office of emergency management, I'm forgetting somebody, dispatch. But anyway, those are appointed officials. And when they get a request, they should notify the judge's office. My recommendation is they should notify the judge's office, who should keep a log of this is a request that came in. Now, they got that request because they likely have those records, maybe, maybe not. The judge's office is not going to have those records, most likely. They need to go back to that office to fulfill it and then send it to the judge. And the judge can then share with it. The elected officials, you get a request as a commissioner, you are 100% responsible. And if you respond appropriately or inappropriately, that's going to be on you. Contrary to whatever people's perceptions are about the county, that's a misnomer in the community at large. They tend to think of counties like they do cities, as if there's just one entity. It's actually, there are 22 kingdoms here in the county. I know very well that there are kingdoms here in the county. And so the law makes it very, very clear, it's on you. And so we'll just have to deal with public perception all the time on that. But I don't believe that if the request comes to an elected official, that we should be putting that on the judge's office. It is first and foremost the elected official's job. However, when the request is directed to the commissioner's court, we're in a gray area here. And I believe that when it's directed to the commissioner's court, the best process would be to have the county judge's office be the person the office that notifies everybody, gathers all the information. And
You good with that, Judge?
Yeah. Can we
So-
make a motion on that?
Do we need a motion?
So the other day, I didn't see, and I don't know who else did, what we sent to client. I mean, I visited with him and I don't know that we sent him the information that he was asking. Honestly. Of course, he waited till the last day or the day before anyhow, to contact me back. But I don't know what was sent to him. Was it just invoices or?
you'd be able, obviously, as a member of the court, and the request was directed to the court.
Yes.
You'd be able to review those
Yeah.
files.
Okay.
There's no problem with that.
Because if we just sent him invoices, then we probably didn't send him what he was asking.
I'm, we can get into the details of a particular
Yeah.
request, except I know, for instance, Andy's office they gave a response.
Yeah.
Sometimes there were things in that request that we didn't have.
Yeah,
We don't
absolutely.
have it. We
Yeah.
don't have to give it. We don't have to create it.
Yeah.
Although I do want to put the caveat, if you have the information and all that's necessary is to create a summary of that information, you do have to create that document. if you
Yeah.
have it, you can.
Well, I was curious about there was a request early on that I didn't know anything about. And so when we got the request to the court, it didn't make any sense. And so to me, because there was some more background. So I actually called him and he did finally get back with me and explain what he was looking for and some of what he was doing. And I don't know that there was anything to it other than, like I said, if you just sent him invoices, that wasn't what he was asking to a certain extent. I mean, I'm sure the invoices may suffice, but he was asking for more stuff too.
Well, and one of those things as an elected official, when you get a request, you can ask for clarification, you can ask for you can make those kinds of requests. So when a request comes to the commissioner's court, it would be best practice for all 5 members of the court to see the request and pitch in your thoughts and suggestions. And again, having that one central point of response is good. But you should all have input in that.
Yeah, because the only thing I knew of is, I didn't have any information that he was looking
I
for,
wouldn't either.
and that was my response.
Correct me if I'm wrong. If he asked for X, Y, and Z, but we only have A, B, and C, we give him what he asked for, the X, Y, Z.
Yeah.
There's no point in going back through all that other stuff. I mean, right? We give him what he asked for.
The Public Information Act is to be interpreted in a manner that is transparent and provide as much information as possible. But when a requester asks for something, you don't have to say, well, we don't have that, but we have this.
Right.
And that's, there's no legal requirement to do that. And when people do that when they make requests to our office, Mr. Durham has made me responsible for our PIA responses. I hesitate to make suggestions and recommendations because I think that you might be opening up certain liabilities that you shouldn't be encountering. But if they ask for something, we've got it, we're giving it to them.
Sure.
If,
Allowed to.
so 2 things. I think it kind of goes back to, I say it a lot, there's right and there's kind of dead right. Yes, absolutely. Everybody's responsible for their own world.
That's not just a right thing, that's the law.
That's what I'm saying. That's the dead right part. That's what I'm saying. That's the dead right part. Yes, we can always fall back on that, but does the county judge, I'm gonna put words in your mouth, I thought. Does the county judge want to find out that the sheriff didn't respond to 3 public information things when the newspaper calls him or somebody files charges? Is that how he wants to find out? He's like, I didn't even know there was even a public
I
information.
understand your concern for
Well,
that.
hang on, let me finish then. So it's not a concern. It is we don't have to do that. We have to do this. We have to answer them ourselves. We don't have to do this over here. But if I was to ask our elected officials, all 21 others, what are the charges associated with responding to a public information? How much are you going to invoice this guy? You know what they're going to say? I don't have a clue. I'll never charge anybody anything. Nobody.
I can tell you the ones who do. Almost everybody runs their
You do.
public information requests by me.
Yeah.
And I'm aware of the ones who know how to do that. If you don't know how to do that and you'd like advice on that, that's what I'm available to help you with.
But nobody, other than people who do it regularly, are going to know that. So why not put a policy in place? And just, you don't have, they can still answer it. They can do it. It just be like, hey, if you get an information request, you notify the judge, hey, it's February 10th. I got a PIO. It's due February 21st. That's all it takes.
I apologize for interrupting you. I'm afraid that policy may be unconstitutionally shifting authority to the county judge that he does not have.
It's just, all right.
I hear what you're saying.
Obviously,
I'm very much opposed to that because I
Obviously.
believe that if the elected officials take care of their business, that's what needs to happen. That's what the law says, that's what they need to do. I've never seen where a county judge had the authority
I'm
to
not saying,
monitor public information requests for other elected officials.
not an authority over it, just a clearinghouse. Hey, I sent a public information request to X official. I never heard back from the guy. Well, and he's calling the judge because that's who people in town call because they think we all work for the judge. So they call the judge and they say, hey, I sent a thing to office of so-and-so. I didn't get it. Oh, well, let me check. Oh, I never got that. Well, Or
So-
yes, he called me on this so-and-so day. I got it written down right here. You should have responded.
When the judge gets a call like that, he can reach out and ask us. I get 10 public information requests a week.
Mhm.
And I know other offices who get more. You need to hire another person to work in the judge's office to keep up with all that.
There's no, okay. I'm
Okay,
good
let's
with it.
come back to the
I'm fine with it.
directed
Let's
to
move on.
Commissioners Court.
I'm good. Let's go.
Okay, I'm gonna make a motion that when a public information request is made to Commissioners Court, the county judge's office will be held responsible to send out requests for information from each person, collect it and respond to the person, to
I'll
the
second that.
request.
The commissioner
Yes,
or appointed.
Andy,
of the,
No, no, no.
from the Commissioners Court.
second. Andy's got it.
Have one. If there's some need to contact back for, when as you said, to clarify or to seek additional, who's responsible, who would be able to do that?
My recommendation is the county judge.
So you're saying like, if Danny wanted to talk to the person, he's gotta run through us?
No, Andy's question is this, gentleman made a request. Andy wasn't sure, does he want this or does he want that? He wanted a clarification.
That
I
comes to,
believe that he should tell you that.
I got you.
should reach out to.
Relay the
him.
message.
Gotcha.
Yeah.
Okay.
And as a member of the Commissioners Court, if it's directed to the court and you want to do that, that's fine, but you need to communicate that to the judge. So that he knows, so the guy's not getting 5 phone calls about the same topic.
Yeah.
Or 5 requests.
everybody good with that?
Oh,
Yeah, I'm good with it.
Good.
What you got, Gary? What's it say?
I got one more question about that. Your motion that included appointed officials
No.
that work under Commissioners Court.
Nope.
It's
This is for
directed at
Commissioner
Commissioner
Court.
Court. That's the one that's confusing to me.
That's a totally different agenda item if you want to do that.
I'm asking for clarification.
No,
I'm gonna, let me weigh in on that. So when it's directed to the commissioner, you are the supervisors, either some of the elected, some of the appointed officials are directly under the county judge, I believe it's. Never.
Oh, yeah, that's it.
Not,
Is it-
I'm talking about Andy,
But I know.
EMS.
let him finish.
Right, and so I think just one of the appointed officials reports directly to the county judge. 2 of them report to judges. And the rest of them report to the commissioner's court. And so if the request came to the commissioner's court, then I think it's not just your road and bridge or just your commissioner's office. It would be the appointed officials, Andy's office, for example, that
Under the
report
court.
to you.
Maintenance, anything.
Right.
All in one IT.
Yeah.
That's what I'm concerned about.
So we get this request, we'd send it to everybody that we oversee.
I believe you should, obviously, if you get a request about something that has to do with maintenance issues, you may not need to be sending that to all of them, but you can send it to the offices that you believe might have those records
And the court.
and the members of the court.
Yeah.
But if they request from planning and development, that doesn't do this.
So if a request comes to planning and development, I think that's where planning and development should notify your office. We got a request on.
That usually happens.
We do.
Right, and they've done, I think it's been going on for years.
Yeah.
to be
Yes.
Perfectly honest. They should notify your office, tell you that. Obviously, they're the office that's got to do the responding.
Right.
Because you don't have those records.
Right.
You know, didn't come to the court anyway, but it would be his office responding, but under the elected official of the county judge.
So, I'm sorry.
That's
Just to
okay.
clarify, if I get a request that's directed directly at my department, what we're doing now is we notify them and then we respond directly to the respondent, including.
Right.
Yeah.
Including maybe if we had questions about what they want, right? Not why they want it, but what the details would be. In this scenario, would all my communication goes to the judge's office?
If it's directed to the commissioner's court, you
Keep doing what you're doing, Andy.
If it's directed to my department, then I-
Yeah.
don't change anything you're doing.
Yeah, you're doing what you're doing.
Okay.
What we're dealing with, I got confused on the one that comes to the court.
Yeah.
How do we deal with that? That's kind of why we put it on court anyway.
Yeah.
But this is very nice. You answered all the questions. I didn't have to say nothing, Quinn.
Yeah.
Thank you.
Let's reread the motion.
To approve for public record request directed to Commissioners Court will process to the county judge's office. Appointed offices would notify the county judge's office of that request, but they
That
would
would be-
respond to this. respond to the request from the appointed official's office. That doesn't make sense.
So that's two different things.
Yeah, take the appointed,
Take the,
Yeah, take that
Bottom part out.
apart.
Yeah.
That's already happening. We don't need to do anything to
Right.
change that. It's only about the ones directed to Commissioners Court.
right,
Right.
The judge's office will be the contact point. Reach out to all offices, gather the information, and make the response.
Read it again.
to approve for public record request directed to Commissioners Court will process through the county judge's office.
Perfect. Second. If you ain't got
Commissioner
one,
White already did that.
gotcha.
There's another second.
moving second, all in favor, raise your right hand.
Thank you, Quentin.
Motion carries. Thank you, sir. 31. Discuss and take action on a complete rebuild of a 140H cat maintainer FAS number 10181 serial 02ZK05671 with factory warranty and ability to purchase an extended warranty.
Cheryl, how are we gonna get this done? I'm looking at you.
Surprise.
Surprise. I know you knew it was coming because Lee been talking to you, but,
Yeah. It's a rebuild. And it comes with, nothing is gonna be changing on it because we discussed at first he had said, well, everything, the serial number, everything's gonna change. And I said, oh, that's a whole nother deal, but it's not the case. It's still gonna be the same machine. It's just basically a repair.
so like internal
So-
repairs or something?
Yes, sir. Yes, sir. It's an internal repair. It broke and we're gonna fix it.
Okay. Well, then that's kind of what I was, thought internal repairs would cover it, but that was during my time frame of being out of commission. And I was kind of in between.
So easy enough, huh?
But Patricia,
The difference would be how it is coded. An internal, a repair doesn't necessarily extend the life. If this is a total rebuild, it will be part of the capital asset value. So, how we code it on the ledger may be different than charging it to your repair budget. It's all
Okay.
the same. It's just a
it
code.
doesn't change the fact that we can still do it, right?
No, it does not change that.
Well, we've looked at getting a new maintainer versus fixing this one. And it's quite a bit more money also, but this one here doesn't have all that depth and all that government crap that they put on there. And our guys can work on it, so we're gonna go this route and I make a motion to approve. And do we need to put a top dollar on it or just leave it alone? Because it may fluctuate.
I'll second that.
Moving second, all in favor, raise your hand. Motion carries. 32, discuss and take action on the purchase of 2024 Chevrolet Silverado 1500 VIN number 1GCP88EDXRZ315054 from Sames Laredo Chevrolet in the amount of $44,500 plus delivery of $300 for $44,800 tips contract.
That'll be my motion.
I'll second that.
Moving seconded, all in favor, raise your hand. Motion carries. 33, discuss and take action on order 2025-34, setting the salary of the county court at law judge.
Look who's back. What, Quentin?
Probably not.
Yeah, so, in answer to some questions before, and I know y'all provided you some information. The legislature has changed the way they pay district judges. They've made a significant change in 2019. They made another change in 2023. The one in 2019 is the most important one for your discussion here. And I will say, our office should have told you at the time you were making an appointment of a county court of law judge that you also needed to issue an order setting their salary. And I think the main thing for me here is, in summary, the district judges are now paid on a 3-tier schedule plus a longevity option. And the legislature's intention for county court at law judges was that they would be paid close to, but not as much as what district judges are being paid. There is a hard minimum salary that's calculated using a formula. There is I believe, a hard maximum salary You can pay anywhere in between. But essentially, the hard minimum is to determine how much a district judge with the same number of years of qualifying service, that would be service as a district judge, service as a county court of law judge, service as a district attorney, criminal district attorney, or county attorney, or service on the appellate courts. Add those years together. That's the qualifying years of service. If they are from 0 to less than 4 years, they get a base salary of $140,000 throughout the state. In addition, they get contributions from the counties inside their judicial district. The 3 counties that contribute to the 12th and the 278th, a combination of counties, but it's $18,000. So our district, if you are a brand new district judge with no years of qualifying service, you would get $140,000 plus $18,000 for $158,000. The law says that a county court at law, also from 0 to 4 years of service, would get $158,000 minus $1,000 as the hard minimum. Can't go below that. You have to pay at least that amount. And so $157,000 is your minimum salary. Want to know my calculations? The most you could pay would be about $194,400. You have a couple of problems with that. One, that means you'd be paying for a county court of law judge more than pretty much every district judge in the entire country. I'm sorry, the entire state. And you didn't budget that much. So I don't even know if you could amend your budget to do that. That's a quick summary of it.
So we can pay anywhere from the low to the high, basically.
And if you're following what the legislature would indicate, in this case, you would go at the low. Because the legislature, like I said, they don't
say it though, Quinn.
They say $1,000 less on each one of the tiers. Each tier is $1,000 less. And this is not just a court of law, district judges. This is justices on the courts of appeal, the chief justice on the courts of appeal, the court of criminal appeals. They do this all the way through. It's a clear indication that they want to build a hierarchy as you go up that ladder. But no, you could go all the way to 194 if you really thought that's what you should do.
Are we at the midpoint now, the 161? Is that what?
That was
No.
in Tracy's
That was
with years of service.
So the years of service for your county court of law judge is 0. And so the tier, it's only 3 tiers. It's 0 to less than 4, 4 to less than 8, and then 8 to less than 12. Those are the tiers. And so he's in the 0 to 4 tier. All district judges with less than 4 years of service are getting paid $140,000. And so that, if you follow that pattern, you pay $140,000 plus the $18,000 from the 3 counties contributing, and then take the $1,000 away because the law requires you to do that. That's where you get that 157 minimum.
What's your number, Joe?
I know Amy's back there. Amy, what did we have budgeted for this?
185.
And that's what we was paying the previous judge, right?
And the reason we were doing that, so based on her years of service, qualifying service, in fact, you're paying her that now. Because based on her, actually you gave her $1,000 raise when she became a judge. So that's the state gave her $1,000 raise, you did. But it's based on years of service. And so her first 4 years, she was being paid 140 plus the 18 minus the $1,000.
Okay.
You actually paid her the minimum. You paid her the minimum throughout her time on. You paid her the minimum all the way through.
Well, she was paid, you want to go ahead?
Yeah, that statute, when was that statute put in place?
2019.
Okay,
So
prior to that.
Prior to 2019, the law simply said that you had to pay your county court at law judge no less than see, they kept that 1,000, no less than $1,000 less than a district judge in the county. So they were literally paid what the district judge was paid. But the district judges in those early years for the former county court of law judge and the judge before her and so forth, they were only being paid $125,000 no matter how many years they were on the bench. They did not have a system.
Plus the 18.
They got that. And
Yeah.
it wasn't clear whether the county court of law judge would get that. It was just, they were looking at that base salary. What's happened in 2019 is they gave district judges across the state a big pay increase. And they start them at 140, they move into 158, 154 to 168. They move them up every 4-year interval. And that didn't happen until 2019. So the law back in prior to 2019, so from the former judge, she came on the bench in 2015, her first 4 years in office, her salary was $1,000 less than a district judge. And we had 2 district judges and
So the years of service didn't
did
count.
not count at all. They were
Okay.
not used for any purpose at all. That started in 2019.
Well, then I'll make the motion to apply the salary.
Hold on a minute, Bill. I still got a couple more questions. So I'm assuming, all right, so you accepted some responsibility for this, but I think the court does too, because we should have brought this up. And I'll be just as guilty as anybody, but we don't do appointments at all. I mean, I've only done, this is the second one since I've been here. And so it's something we should all thought about, I guess. I didn't realize it was gonna be that big a deal. But I have definitely learned a lot. I don't know if I'll remember any of it, but I have learned a lot. So, okay, but we've already paid one check, right, Amy?
3 days.
3 days?
You paid 3 days at the 185 rate. You paid the next paycheck at the 157 rate.
Okay, all right. So are we retracting the money or what?
I mean, I would recommend.
Well, I wouldn't either. That's why I'm asking. I mean, whatever it is, it is. We've done, I mean, we're fixing this after the fact is what I'm getting at.
Right. Well, you're fixing it going forward.
yeah.
We have a pay period ending
Yeah.
this week and you're fixing it going.
Okay,
forward.
so he'll retain for the 3 days the money
It's like $200.
that we've spent. All right. And I'm assuming he still wants the job. I hadn't talked to him.
I have visited with the judge. He's fine. In fact, he told me that what he,
Yeah.
I'm not.
I had some early
I'm not gonna
conversations,
speak
but
for anybody
I
else.
hadn't had nothing lately with him, so, okay, all right. Well, then-
Now I make the motion to set the county court of law judge salary at $157,000 total, $140,000 from Walker County.
So,
Yeah, no, just be real clear. The whole salary is.
It all comes from us.
plus the 18,000.
Yeah,
Okay,
that includes that.
157 total from.
It's matched.
Yeah.
So, that's my motion.
And the auditor
To make your motion to
looked it up again.
accept
The
this.
state actually, they've always done this. They give you money.
Let me read your order over here.
Yeah, no, yeah.
I'm gonna go ahead and just read the order. I make the motion to approve order number 2025-34, establishing the salary of the county court at law judge at $157,000.
so from my side.
Moving second, all in favor, raise your right hand. Motion carries.
Thank you, Quentin.
Planning development. 34, public hearing concerning plat number 2024-008, replat of lots 10, 19, and 20 of the Prescott Estate subdivision. Time is 9:53. Anyone here to speak upon that? All right, Andy, you're up.
So it's a replat. It was originally 3 lots in subdivision. It was converted. It was combined, and now they're trying to split it back into 2. Bouncing ball.
All right, time is 9:54. Public hearing is closed. Number 35, discuss and take action on plat number 2024-008, replat of lots 10, 19, and 20.
Approval. Second.
Moving second, all in favor, raise your right hand. Motion carries. 36, discuss and take action on exception number 2024-012, Four Star Real Estate Group number, or incorporated 9.988 net acre tract.
You approved the variance on this earlier. That's the reason I'm going back to court with it, because it's got a variance from Commissioner's Court attached to it. This is the variance you guys approved, the frontage and acreage being slightly.
Variance was because acreage was under 10 acres and it's like 0.2.
988.
Yeah.
Move for approval.
Second.
Moving second, all in favor, raise your right hand. Motion carries. 37, discuss and take action on George and Maria Toth request for variance to sections B 2.3 and B 2.1 of Walker County subdivision regulations regarding minimum staff width for flag lots and minimum road frontage for their property.
So Mr. and Ms. Toth were
Yeah.
earlier, they, Commissioner White has since had a chance to go out to the site and look at the site. Their initial request was, to have a staff and a frontage width below what the subdivision regulations require. They're here today, I think.
Yeah, y'all wanna come up? Andy and myself met with them on the road the other day. And kind of agreed on a 40 foot as close as we can get to it and still have that half acre
For visual. I don't know.
lot. I mean, y'all got any more numbers since I've seen you?
Pretty much stayed at the 40 like we were talking about, because, you had mentioned that. Yeah.
Which give you a little bit more than a half acre, right?
At the
25
40, then it would be, yes, a little bit more than a half acre, which would help us with the septic systems require.
Okay. So, you good with it? You good with it?
Yeah, so it'd be 40 foot on the staff and then the remainder go with the second lot. This variance would be a variance to those frontage requirements. They would still have to meet all the other.
Okay.
Development requirements.
Gonna work for you? 40 foot?
I could make 40 foot work, yes.
Y'all
Better
good
than
with 40
30.
foot?
Oh, yeah.
I'll make a motion to approve the variance to 40 foot.
Second. Moving second, all in favor, raise your hand. Motion carries.
Good luck.
38, discuss and take action granting of exception to plating and subdivision requirements for the portion of the residual of a called 56.257 acre tract located west of Sam Slot Road and described as Welborn, 13.860 acres of land, a deed filed in instrument number 100-535 based on the subdivision by separate use caused by the creation of Sam Slot Road.
So this originally came about for the court several years back. But there, and the original application was to provision the tract by the road, on the paths of the road. What's before the court today is just dealing with this tract. It's an out tract of 2 acres that was taken out well after the road was constructed on this side of the road. I'll be honest with you, the research I've done, the deed that I have just calls it 2 acres and there's not a lot of information with it. So there's some compliance questions on this side of the road. The center of the application is that there was a piece of property here. This is the public road. Been there for many years. The owner is basically, the claim is that residual of the tract that's on this side of the road be cleared for compliance with the subdivision. Just this piece here, as the item is written, that's what it would allow me to go forward and this 13.860 acres that's to the east as compliant for permit with the subdivision.
And it doesn't affect the other
It
side.
would not affect compliance on that side until some future action is taken.
So is it all different owners now? Every one of those tracks is a different owner? Or
This is,
he's by himself?
and this is, as far as I know. I'm not the title company, but yes, I think they're 3 different.
I mean, to me, it would have been a good time to fix that 2 acres up there in the corner as a part of the,
Yeah, that's a can of worms. I'm not willing to jump in.
That's y'all's call.
yeah.
I don't want to.
If it was the same owner, yeah, but if it's 2 or 3 different people, then.
Well, yeah.
Sammy,
Hey, Sammy. Sorry, I didn't see you there.
Sammy Wellborn.
Hey, so the 2 acres up there, that's owned by Tressa's Slot now. So it was deeded to her when Nomalie Slot passed away. So that's her portion. She has a right of way. And then my dad sold the 5 acres on the other side to Joey Adams, Kevin Tomzak. That's on their LLC. So I'm just trying to get the other portion
Here.
deeded for the plating.
Sammy Wellborn.
Continue building on the property.
My motion. is-
WELBORN.
Presented.
What was your motion, Brent?
Prove it as presented.
Second.
It's Jimmy Ray. Oh, wow.
Jimmy.
Seconded that?
I did.
Sorry. Moving seconded, all in favor, raise your hand. Motion carries.
All right.
Thank you, Sammy.
Thank y'all.
39, discuss and take action on preliminary plan approval for plat number 2023-008 Woodhaven subdivision, Daniel J. Tover survey.
So this is a preliminary plan that they're putting forward. There's no new road construction, but there is some drainage construction involved in this, so they're trying to get the plans approved. I think their approach that they're wanting to take is to move forward with construction, get substantial completion prior to filing the plat. So we need preliminary plan approval from Commissioner's Court before we proceed. This has been reviewed by Blyle. They're online. Stephanie,
Yes.
are you there?
She's on.
Yes, sir, I'm here.
Do you have any comments for the court on the plan review?
No, I don't.
So we're at the point of no comment on the plan review.
Correct, yes. Yes, the plans, meet the requirements of the regulations. We did have 4 items, with the conditional approval, being just to complete the development permit, to provide the final copies, so that we can confirm that they align with the documents that are approved, and also to provide, the subdivision bond once they do record the plat.
Okay, that was my question. I was gonna bring up the subdivision bond.
That's the 10% bond. So normally the policy, even if we waive even if they choose to construct in lieu of bonding, there is a 10% bond that goes in place. Usually, public infrastructure involved, right?
I thought the 10% was specifically for public infrastructure.
Well, it includes everything that was in the original bond, which is all the regulated. So if you guys, if they want to have that bond waived at that point, they're gonna have to specifically request a variance from the district. Which they could do, but on the conditions that they have.
Okay. So we have basically 4 conditions, right? Okay, do you have a copy of that letter?
Back up.
Send it back up? Yeah, okay, so my motion is gonna be approved, with the conditions listed in the law letter.
I think you.
It is.
No.
It's
It's not in the plat. Not ours.
Provide all letters should be complete development permit. Provide
I like the bottom. Yeah.
Format applicable to the county and blah, review final.
That's
documents.
That's in there.
Yeah.
To approve the public hearing
Oh.
conditions
With the conditions.
without minutes.
Just reference that letter like we normally do is fine. I just wanted to make sure I had said that.
Your motion?
Yes, sir.
I'll say.
Moved and seconded, all in favor, raise your hand. Motion carries. 40, discuss and take action on final plan approval for plat number 2023-055 Jones Reserve subdivision, LM College Survey A10.
It's gonna be similar. A lot of associates completed our farm plan review. We got to the point of basically of no objection with a couple of comments that be added as contingency. Stephanie, do you have anything to add related to the Jones Road?
No, same things, but just to make sure that all the administratively incomplete items are addressed prior to recordation.
Conditions of administratively complete development permit.
Second.
Moved and seconded, all in favor, raise your right hand. Motion carries. 41, discuss and take action on final plat approval for plat number 2023-055 Jones Reserve subdivision.
I'm gonna go back to the previous one. The agenda says date 5/2/2005. It's 2024. Oh, this one that we're on is the same way. It's just an error typing there. I wanted to point it out. Sorry.
Same thing with
That's my motion to approve on that letter.
Same second.
Moved and seconded, all in favor, raise your hand. Motion carries. 42, discuss and take action on requests for addresses and permitting for lots off of New Road and property sold within Walker County by Pine Woods Ranch Partners LLC.
You need some help?
What'd you do to yourself?
Pass those down.
What'd you do to yourself?
Got a story? You don't want to ask that in open court.
Come on, there you go, then.
Leave your right hand.
Yeah, don't be asking questions like that. in open court. You might better wait till court's
I'm
over.
gonna just catch him after.
See, you don't want to talk about it.
Yeah. Maybe be none of my dang business.
Don't want to pay that either.
We talked about.
I don't really need to-
No, I don't really.
Look
You know what?
at this. Look at this.
Me too.
In June of 2024, this commission report reviewed some vision that was done at the edge of the county, some conversation about the county line. The county line was represented on that exhibit that was before court. It did not include this road
That yellow line up there.
here.
Yeah.
Or these lots that are. Originally, it was just off of that one. road.
Yeah.
It was off of this, and then there was a few flag and regular tracks off of Bo Brown. So it's come to our attention, we've had some requests for addressing along this road. We have no permits on that road, floodplain application for the subdivision. We have no application for the onsite wastewater on that. And now we have address requests being submitted. We don't have any commissioner's court approval of the roads because normally that's done at the time that the roads are approved and platted under our subdivision regulations. So here I am before commissioner's court. Also, I can assume that we're having an addressing request. They're going to be permit requests forthcoming for structures on the lots.
OSFs.
So sewage facilities. And we have several issues with existing regulations. Our onsite wastewater regulations require a study to be done under the state code. Our floodplain regulations require studies to be done under under them prior to the subdivision. You have a subdivision regulations that require minimum frontage on new lots created that don't have frontage on existing roads. The lots are, as far as I can tell, the lots that I know about are over 10 acres. That was discussed before as far as the size. But I need some, I'm here before court to A, make the court aware, and B, say, what do you guys want me to do with this? Because they have requested particular names for the roads, but that's outside any process that I've dealt with ever and doesn't follow the regulations that court has passed previously.
So the regulations we have in place, Sandy, even if the lots are all over 10 acres, we still have to go through our process, correct?
Our policy says that if the lots do, yes, it requires us to go through the process of the subdivision. Still has to be either accepted, and if it is, section 11 requires that existing road or a road that meets the subdivision regulations. There's some things laid out in subdivision regulations that allow for alternative frontage types.
My name is Tyler Epstein.
Hold on, Tyler.
Yes.
Take your hand off. You're going to address us.
Yes, sir.
What's your last name?
Epstein.
Tyler Epstein.
Yes, sir. Here on behalf of Pinewood Ranch Partners. So we meet the legal exemptions under 232.015F. And those are clarified in the subdivision regulations, appendix section 1 and appendix A, section 2.2.1. And so everything was done according to the exemptions granted by the state of Texas on that. And then on your 911 addresses, I got this from Andy this morning, but kind of tells you how the sausage is gonna be made when issuing 911 addresses. And it has a section in there, I believe it's, D5. I apologize if I got that numbering wrong. Says private roads, and multiple structures should be numbered individually as public streets and roads, the same as. But that's the situation. Everything was done according to state law. And was done after September 1st, 2023, when this law was updated, which I believe y'all subdivision regulations were just updated recently to include that in there.
We have Quentin doing executive session.
But like to just one question, the exception you're giving here is the 10 acre.
That's what I was arguing.
So the exception he cites is valid to exempt him from plating requirements. It does not exempt him from subdivision regulation requirements.
That's a statement we made last June.
Yeah.
And you seemed acceptable to that last June, when we sort of stipulated that, okay, we're not gonna oppose the county line conversation. We felt like we had a valid argument, but it wasn't something we were gonna die in that ditch on. And then we conceded that, okay, it's over 10 acres, so you don't have to plat. But you were still subject to our subdivision regulations. There's just no way you're not.
The state exempted us from so the only reason that we fall into the regulations there is if we desire a plat, or have to do it under 232. 232 specifically removes this from the authority of the commissioner's court to grant these addresses. That it's a valid build. It's everything.
I think you told us that last time and we disagreed with you on all that too.
Yes, sir.
Yeah. Ally, who's online to talk on this? Anybody online?
There are some people that are not county employees,
Is
but
there anybody online that would like to talk upon this subject?
there's a Marjorie Cox, Catherine Cleveland, and somebody named Partner. Everybody else is county employees.
I want to, yeah.
Okay, we're gonna go into executive session under 551.071, time is 10:12. All right, we're back from executive session at 10:39. Still on number 42.
Judge, I'm gonna make the motion to deny the request to issue addresses and permitting for lots off of new roads in property sold in the Walker County by Pine Woods Ranch Partners. LLC.
Say one thing.
Second.
Moved and seconded, all in favor, raise your right hand. Motion carries. Oh, many public comments? Questions from media? Commissioners Court. All right, we're gonna adjourn at 10:40.